Good morning. Today we are going to see the topic implied warranties. Okay, what is a warranty? Warranty is a stipulation which is collateral to the main purpose of the contract. So if the warranty is broken by the seller, the buyer cannot cancel the contract. The buyer is just entitled for getting compensation. Okay, condition is that stipulation which goes to the root of the contract. It is the main purpose of the contract. So if the seller breaks it, the buyer can cancel the contract. But in a warranty, the buyer cannot cancel the contract. Buyer only can get compensation. Okay. Now warranties are either express or either implied. Express warranties are those which are being mentioned by the parties while entering into the contract. They are expressly mentioned in between them. But implied warranties are those which are implied by law. Law says this is an implied warranty that must be fulfilled. But the treatment is different, isn't it? Because that must be fulfilled. But if it is not fulfilled, the contract is not cancelled because it is just a breach of a warranty. Okay. Now the first implied warranty which is mentioned in section 14, subsection B is what? Warranty of quiet possession. When a buyer is purchasing the goods, he is becoming the owner now. So the seller hereafter should not disturb his quiet possession. By buying the goods, the buyer is getting a right of quiet possession because now he has become the owner. In a contract of sale, unless there is a contrary intention, there is an implied warranty that the buyer shall have to enjoy, or the buyer shall have and enjoy quiet possession of the goods. If the buyer is in any way disturbed in the enjoyment of the goods in consequence of the seller's defective title to sell, he can claim damages. Means he can claim compensation from the seller. So implied warranty of quiet possession is there. Second is what? Warranty of freedom from encumbrances. Encumbrances means the charge or the burden which can be created on the title by the third party. So when the seller is selling the goods, he has to give a warranty to the buyer that his possession will not be disturbed, and there is no charge of the third person. Third party is not involved here. So here is a warranty for freedom from encumbrances. Okay, so there is an implied warranty that the goods are not subject to any charge or right in favor of the third party. If his possession is in way disturbed by reason of the existence of any charge or encumbrance by the third party on those goods in favor of that third party, the third party will interfere here. The third party will disturb the quiet possession of the buyer. Okay, but if this thing happens, the implied warranty is broken, then the buyer shall have a right to claim compensation for breach of warranty. So the third party should not have any charge, any encumbrance on those goods, and if they are there before the sale, the seller has to do all the things, rightful things, by which the charge is being removed of the third party. Okay, so this is the second implied warranty, that is for freedom from encumbrance. The third is what? Warranty as to quality or fitness by usage of trade. What we have seen, there is no implied condition as to fitness, but there may be an implied condition as to custom. Means by custom, if the goods are being sold for a particular purpose, then those goods should fulfill that purpose. It means implied condition as to custom is there. Now we are telling about implied warranty as to quality or fitness by usage of trade. Means the trader is selling, the seller is selling the goods, his business is there, his trade is there, and it is a usage of that trade that whatever goods he is selling, that will fit your purpose. And if it fits, it's okay. But if it does not fit, then an implied warranty is being broken. Okay, an implied warranty as to quality or fitness for a particular purpose may be annexed, may be connected by the usage of trade, and if it is not fulfilling, then implied warranty is broken. The buyer can claim compensation, and if it is connected with the custom, then implied condition is broken and the buyer can cancel the contract. Okay, this is the third implied warranty. Now the fourth is what? Warranty to disclose dangerous nature of goods. Now when the goods are dangerous, if they are containing some dangerous things and all, or they are to be handled with care, then the seller has to tell the buyer that better handle it with care. This is danger, otherwise it will become dangerous. He has to mention at least on that packet, or some notice must be inserted. Notice must be mentioned that handle with care. Okay, so if he does not do that and something happens, then an implied warranty is been broken. Where a person sells goods knowing that the goods are inherently dangerous, or they are likely to be dangerous to the buyer, and that the buyer is ignorant of the danger, he must warn the buyer of the probable danger. Otherwise, he will be liable in damages. He will be liable for compensation. Okay. Now, these are the 4 implied warranties mentioned in law. Okay. Connected to this implied condition and warranty, we are having one concept called as caveat emptor. Caveat emptor means what? Let the buyer be aware. See, the buyer comes in the market, he will see the goods, he will purchase the goods. The seller is not representing anything, or whatever he is representing the truth. Then if the goods do not fulfill his purpose and all, if they are not fit for his purpose, the buyer is responsible for himself, because the seller is not telling anything. So let the buyer be aware. In a contract of sale of goods, the seller is under no duty to reveal unflattering truths about the goods sold. Therefore, when a person buys some goods, he must examine them thoroughly. If the goods turn out to be defective or do not suit his purpose, or if it depends upon his own skill, means he himself has purchased, his own skill or judgment, and makes a bad selection, he cannot blame anybody than himself. Okay. So, caveat emptor means buyer be aware. So, the buyer must be aware in the market. Okay, now what the seller is doing? Seller is clearly announcing that he is selling some defective goods. The buyer should not purchase it, because the seller is telling the goods are defective, but the buyer purchases it. Thereafter, he can't blame the seller, because the seller has given proper representation. Truthful representation has been made. So, if the defect which the buyer thought will be less, but if it amounts to more defect, then he has to accept the goods. The contract cannot be cancelled and all, because he himself is to blame, himself only. Okay, because he has purchased those goods by his own selection. Therefore, the seller is not liable. This is a doctrine called as caveat emptor, let the buyer be aware. Okay, now this doctrine can be misused, because let the buyer be aware, because the seller can tell the buyer was aware of this, I am not responsible for that, isn't it? He can say like that. So what law has done? Law has created exceptions to the doctrine of caveat emptor. Means caveat emptor is telling let the buyer be aware. Okay, the buyer will come in the market, he will see thoroughly the goods and purchase it. But by seeing the goods, if he is not able to understand what the defects are, he can't see by the naked eyes whatever the defects are, then what will happen? He has to rely upon the seller, and implied conditions are there, implied warranties are there. So these are the exceptions to the doctrine of caveat emptor. The doctrine of caveat emptor has certain important exceptions, because these exceptions are there to protect the buyer. Because the buyer, he is aware, he is very cautious enough, but by just his naked eyes, he can't see the defects and all. So what will happen? This caveat emptor doctrine will be misused by the seller. Therefore, we have created certain exceptions, and those exceptions are what? Are implied conditions and warranties. Okay. Fitness for buyer's purpose means when the buyer expressly has mentioned that I want this goods for this purpose, and he relies upon the seller, then here the doctrine will not apply, because the seller will be liable. Sale under a patent or trade name, when the seller is selling it under trade name or under patent, so the person who is the inventor, the patent holder, he will be liable. Or the person who is selling the goods in the trade name, the person is purchasing because the goods are of this particular person, he is having goodwill, so he will be responsible if the goods do not fit or the goods are not proper. Okay. In the case of a contract for the sale of specified article under patent or other trade name, there is no implied condition that the good shall be reasonably fit for any particular purpose. But the person who is having that trade name, the businessman and all, he will be responsible for breach of implied condition as to fitness, as to usage, or as to custom. Okay. The next is what? Mercantile quality. Whenever the goods are being sold, the goods should be commercially saleable, and if the goods are not commercially saleable, implied condition is been broken, the seller is liable. Okay. Now these are, you can say, implied conditions. So these implied conditions are exception to the caveat emptor. In implied condition, what happens? The seller is liable. The contract can be cancelled. So these are implied conditions specifically been created as exception to caveat emptor. Doctrine of caveat emptor protects the seller. Let the buyer be aware, isn't it? But the exceptions to the caveat emptor protect the buyer. Okay. Bye bye. See you in the next video.